It's Saturday, November 30th, 2024, 3:17 p.m. Michigan Court of Appeals case. Try to hold it as steady as I can. Summit Township versus Bankval Thulin. My name is Mr. Bankval Thulin. The case number is 373263. I'll go document by document. They're all filed. You can pause and read each document as you go if you want. This has to do with the fact that the Index of Authorities, I got 60-some pages here. I'll get into that. Constitution, Article 1, Section 8, Clause 15. 10th Amendment of the United States Constitution's in here. And the State of Michigan Military Act is in here also. That takes most of it. Statement of jurisdiction. Statement of questions. Take these and go one by one. Did the Fourth Judicial Circuit Court err in the ruling on defendant appellant's petition for interlocutory appeal case number 24-2631-AR dated October 23rd, 2024? My answer is yes. Did the Fourth Judicial Circuit Court base their court's ruling in defendant appellant's petition for interlocutory appeal case number 242631-AR dated October 23rd, 2024, on a previous petition and review of decision by Judge Gakey Jr., Robert K. Gakey Jr., to dismiss my motion for dismissal with prejudice dated July 8th, 2024, in case number 241679AR? My answer is yes. Did the judge, or is a judge required to and/or should the judge recuse themselves when under investigation because of a complaint filed by the defendant appellant with the Michigan Tenure Commission? My answer is yes. Does the Constitution of the United States, Article 1, Section 8, Clause 15, delegate law enforcement specifically to the United States government? My answer is no. The plaintiff appellee, which is the prosecutor, gave a non-committal, nonsensical answer about making a cake and throwing it out the window of a car while driving down the road. See 12th District Court, September 24th, 2024 transcript, page 12, lines 6 through 17. And lines 1 through 5 are the plaintiff's perjury as that I gave video proof of his office being served. The court says, no answer. The court did not base its ruling on my interlocutory appeal dated September 4th, 2024, but wrongfully based its ruling on a previous petition for review and decision by Judge Robert K. Gakey Jr. to dismiss my motion for dismissal with prejudice dated July 8th, 2024 in case number 24-1679-AR. 12th Judicial Court says, law enforcement system is illegal. Yep. See 12th District Court, September 24th, 2024 transcript, page 10, lines 20 and 21. And yet, the 12th District Court on September 24th, 2024, denied defendant's motion for dismissal with prejudice, claiming that it was frivolous and lacked merit because it was based solely on the United States Constitution. See 12th District Court, September 24, 2024, transcript, page 14, lines 24 and 25, and page 15, lines 6 and 9. Does the Constitution of the United States, Article 1, Section 8, Clause 15, delegate law enforcement specifically to the United States government? Defendant appellant says no. Plaintiff appellee says, gave the non-committal, nonsensical answer about making a cake and throwing it out the window of a car while driving down the road. Yeah, same thing I said earlier, same lines in the transcript to prove it. And the court said, again, gave no answer. The court did not base its ruling on interlocutory appeal dated September 4th, 2024, but wrongfully based its ruling on a previous petition for review of decision by Judge Gakey, Robert K. Gakey Jr., to dismiss the motion for dismissal with prejudice dated July 8, 2024, case number 241679. The 12th District Court said, law enforcement system is illegal. Yep, we went over this already. 12th District Court, September 24th, 2024, page 10, lines 20 and 21, and yet the 12th District Court on September 24th denied my defendant's motion for dismissal with prejudice. They said, claiming it was frivolous and lacked merit because it was based solely on the United States Constitution. See 12th District Court, transcript page 14, lines 24, 25, and page 15, lines 6 through 9. Does the United States Constitution, 10th Amendment, specify that the powers not delegated to the United States Constitution, not prohibited by it to the states, are reserved to the states or the people? Defendant says yes. Does the Constitution of the United States, Article 1, Section 8, Clause 15, by not delegating law enforcement specifically to the state, actually prohibit the state from law enforcement according to the Constitution of the United States, 10th Amendment? Defendant says yes. The defendant appellant, that's me. Does the Constitution of the United States, Article 1, Section 8, Clause 15, delegate law enforcement specifically to the militia? Defendant appellant says yes. Throughout the history of the United States, has not always the militia been made up of the people? Defendant appellant says yes. Does the Constitution of the United States, Article 1, Section 8, Clause 16, say to provide for organizing, arming, and disciplining the militia, for the governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of officers and authority of training the militia according to the discipline prescribed by Congress? Defendant appellant says yes. Is the Jackson County Sheriff Department the militia according to the Michigan Military Act, Act 150 of 1967? Defendant appellant says no. Does the Jackson County Sheriff Department constitute a constitutionally legal law enforcement? Defendant appellant says no. When the defendant appellant was arrested by the Jackson County Sheriff's Department deputy, was my arrest constitutionally legal? Defendant appellant says no. Now we go into the statement of facts. On April 29, 2024, Bank Val Thulin was walking on Robert Street near Tyson when a Jackson County sheriff's deputy arrested me and wrote me a ticket number SU 524839, for allegedly violating a Summit Township ordinance, SU 130.03E1I, possessing a knife with a blade over 3 inches in public, Summit, when in fact I was in Blackman Township, not Summit Township. On June 11th, 2024, I was in the front lobby of the Jackson County Sheriff's Department to pick up evidence that I had issued a subpoena for when 2 Jackson County Sheriff's deputies arrested me allegedly for owing child support. On June 12th, 2024, I went before Judge Nye, a visiting judge from Hillsdale County, there to replace Judge Diane Rapley, who I was told was on vacation. Judge Nye gave an order stating that I do not owe any child support, and also ordered the friend of the court to give me a copy of an accounting balance sheet showing that I had a zero balance. On June 12, 2024, Judge Diane Rapley came back to work. Judge Diane Rapley wrote a new court order claiming that, again, that I owed $23,000 in child support. I, Bank Val Thulin, on July 2nd, 2024, filed a request for investigation form with the Michigan Tenure Commission naming Judge Diane Rapley, P48973, also naming Judge John G. McBain, P47476, and as such, Judge John McBain, P47476, would know that I filed said complaint as that my name is on all the court documents submitted to the Michigan Tenure Commission and on the request for investigation form. On July 9th, 2024, I filed a petition for review of decision by Judge Robert K. Gakey Jr. to dismiss my motion for dismissal with prejudice, dated July 8th, 2024, case number 241679AR, with the 4th Judicial Circuit Court, and I specifically asked the clerk not to have both Judge Diane Rapley, P48973, also naming Judge John G. McBain, P47476, assigned to my case, and I told her that I had filed a complaint against both of them, both Judge Diane Rapley and Judge John McBain, and why. The court clerk told me she would have to ask if it was possible, and she got up and walked away. A few minutes later, the court clerk returned and told me that Judge John G. McBain, P47476, had said that everything that I file with the court is to be assigned to him. That's what the court clerk told me. On October 11, 2024, Judge John G. McBain, P47476, gave a court order denying my petition for review and decision of Judge Robert K. Gakey Jr. to dismiss my motion for dismissal with prejudice, dated July 8, in case number 241679AR, that I, Bank Val Thulin, filed with the 4th Judicial Circuit Court. On October 15, 2024, I, Bank Val Thulin, filed my petition for interlocutory appeal with the 4th Judicial Circuit Court, and again was assigned to Judge John G. McBain, P47476. On October 23rd, 2024, Judge John G. McBain, P47476, gave a court order denying my petition for interlocutory appeal, and Judge John G. McBain, P47476, ordered was not based on my petition for interlocutory appeal, but was in fact based on my previous filing of the petition for review by decision by Judge Robert K. Gakey Jr. to dismiss for dismissal with prejudice dated July 8 in case number 241679AR. Judge John G. McBain, P47476, should have recused himself from any case that I am involved in, but he did not. Judge John G. McBain, P47476, clearly showed his bias against me by basing his October 23rd, 2024 order denying my petition for an interlocutory appeal, case number 242631AR, on a previous petition, case number 241679AR, and on my petition for interlocutory appeal, case number 242631. Okay, that's, go down the statement of table of contents. That's the question. Now we go to argument one. Argument one. Get a clear shot of the first page. I believe that Judge John G. McBain of Fourth Circuit Court erred intentionally out of bias and or malice in his ruling on defendant appellant petition's interlocutory appeal, case number 242631AR, dated October 23rd, 2024. Judge John G. McBain of the Fourth Circuit Judicial Circuit Court should have recused himself from any and all filings that I made with the Fourth Judicial Circuit Court. Standard of review. The standard of review is the legal reason why he should have recused himself. And that's MCR, Michigan Compiled Rules, Michigan Court Rules, 2.003C1B. Judicial disqualification in Michigan. Go down to C. Where is it? Disqualification warranted. This section sets out the grounds for disqualification. Situations involving these grounds discussed in Part 2 under MCR 2.003C1, disqualifications of a Judge 3 is warranted for the reason that it includes, but not limited to, the following. Judge is biased or prejudiced for or against party or attorney. Judge based on objective or reasonable perceptions has a serious risk of actual bias impacting the rights of the party as enunciated in Caperton versus Massey, and then it gives the court case numbers. You can look it up. Failed to adhere to appearance of impropriety, standard set forth in Canon 2 of the Michigan Code of Judicial Conduct. Analysis. Judge John G. McBain, P47476 of the Fourth Judicial Circuit Court should have recused himself. Instead, he showed bias and abuse of discretion. We'll set those right there. We'll pull this one up. Argument number 2. I believe Judge John G. McBain of P47476 of the Fourth Judicial Circuit Court erred intentionally out of bias and or malice in his ruling of defendant appellant a petition for interlocutory appeal, case number 242631AR, dated October 23rd, 2024, by neglecting my United States constitutional issues that I, Mr. Bankval Lewin, the defendant appellant, put forth in the petition for interlocutory appeal. Case number 24631AR, dated October 14th, 2024, which is based on defendant's 12th District Court motion for dismissal with prejudice dated September 4th and filed on September 5th, 2024. Judge John G. McBain, P47476 of the 4th Judicial Circuit Court should have based his ruling on the defendant appellant's petition for interlocutory appeal, and yes, the judge wrote petition with 2 E's. That's how he put it. You'll see that in the actual ruling in a minute. Case number 242631AR, dated October 23rd, which is based on the 12th District Court motion for dismissal with prejudice dated September 4th and filed on September 5th. Judge John G. McBain, P47476 of the 4th Circuit Judicial Court did base his ruling on defendant appellant's petition of interlocutory repeal, case number 246, dated on a previous petition for review. He based it on a previous petition. His ruling he based on a previous petition for review and decision by Robert K. Gakey Jr. to dismiss my motion for dismissal with prejudice dated July 8, 2024, in case number 241679. So what he did was he didn't base it on my interlocutory appeal. He based it on a previous one from his ruling of my interlocutory appeal. He based on a previous petition several months before. Real simple. He completely ignored the entire content of my interlocutory appeal. Standard of review, MCL section 600.1701, revised Judicator Act of 1961, excerpt Act 236 of 1961. Neglect or violation of duty or misconduct, power to punish by fine or imprisonment, section 1701. The Supreme Court, Circuit Court, and all other courts of record have the power to punish by fine or imprisonment or both persons guilty of any neglect or violation of duty or misconduct in all of the following cases: attorneys, counselors, clerks, registered sheriffs, coroners, and all other persons in any manner elected or appointed to perform any judicial or ministerial services for any misbehavior in their office of trust or for any willful neglect or violation of duty, for disobedience of any process of the court or any lawful order of the court or any lawful order of a judge or the court or of any officer authorized to perform the duties of the judge. Analysis. Judge John G. McBain, P47476 of the 4th Judicial Circuit Court, did show bias and abuse of power by not basing his ruling on defendant appellant's petition of interlocutory appeal, case number 242631AR, dated October 23rd, 2024, on the defendant's appellant's petition for interlocutory appeal, case number 242631AR, dated October 14th, 2024, which is based on the defendant's 12th District Court motion for dismissal with prejudice dated September 4th, 2024, and filed September 5th, 2024. That's pretty straightforward, people. I had some people read this already, and they told me even a damn kid could understand it, so figure we're doing all right here. Argument number 3. The Constitution of the United States, Article 1, Section 8, Clause 15, delegates law enforcement specifically to the militia. The Michigan Militia Act, Act 150 of 1967, does not specify the Jackson County Sheriff's Department as the militia. The Jackson County Sheriff's Department is not a constitutionally legal form of law enforcement. Yeah, that's right, folks. Pay attention. Standard of review. Constitution of the United States, Article 1, Section 8, Clause 15. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, but all duties, imposts, excise shall be uniform throughout the United States. And then you get to Clause 15, which is to provide for the calling forth of the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Now, to provide for the calling forth of the militia to execute the laws of the Union. That is, the militia is to enforce the laws, not the Sheriff's Department. The militia is the only constitutionally legal form of law enforcement in the United States, according to the United States Constitution. The Constitution of the United States 10th Amendment, powers not delegated to the United States Constitution nor prohibited by it to the states are reserved to the states respectively or the people. Well, as you saw, law enforcement is delegated to Congress and the militia. Michigan Military Act, Act 150, 167, an act to provide for the militia of the state and its organization, command, personnel, administration, training, supply, discipline, deployment, employment, retirement, and to repeal acts and parts of acts. Analysis. I, Bank Val Thulin, the defendant appellant, was not arrested by a constitutionally legal form of law enforcement. Therefore, the charge that I was arrested for by the Jackson County Sheriff's Department deputy of violating a Summit Township Ordinance, SU 130.03E1I, possessing a knife with a blade over 3 inches in public, Summit, should be dismissed with prejudice. Now we get to the next little thing here. This is the index of trial court documents. Lay it down, try to get a good view of it here so you can, there you go. Relief requested. All these have to be put in a specific order according to the court. Relief requested. I, Bank Val Thulin, the defendant appellant, request that the court grant my application for leave to appeal or reverse the 12th District trial court decision and grant my motion for dismissal with prejudice, case number 240248 SUOM, dated September 4th, 2024, filed on September 5th, 2024. Now we go to, this is Judge John G. McBain's ruling. And you see here, he did write petition with 2 E's. He's the one that gives the orders. Okay. Nowhere in here, take that apart, in this order does he cover anything. He covers the fact that I was arrested in the background for the knife charge. He talks about a previous petition and motion for stay of proceedings to the district court, lower court's denial, petition for interlocutory appeal, the defendant's argument. Lower court's denial of my motion for dismissal with prejudice with a petition for interlocutory appeal. The lower court did not get a petition for interlocutory appeal. The Fourth Judicial Circuit Court got the petition for interlocutory appeal. Judge John G. McBain got it, not the 12th District Court. And here he goes on, and different date, biased transcripts from hearing different from which defendant appellant based his petition for review and reversal. He's talking about the original from back in July or whatever. It's not the interlocutory appeal that I filed. You can all read that yourself. Court's analysis. Defendant makes no argument to support his contention. I did make argument. Same arguments you just heard me go through right here. I made in the petition for interlocutory appeal. And you'll see that in a minute. Here he's talking about the previous petition for review and reversal in his decision. He's not talking about my interlocutory appeal. He's not basing anything on my interlocutory appeal, but he goes on to deny my interlocutory appeal. This is the petition for interlocutory appeal. This has nothing to do with the petition for review and reversal. One page, real simple. Try to get it focused in here so you can maybe. I'm dealing here with my petition for motion for dismissal with prejudice because of the, where is it? That's right here. This motion for dismissal with prejudice because of law enforcement not being constitutionally legal the way we see it. Article 1, Section 8, Clause 15, right there, see? That's what this deals with. I based my motion for dismissal with prejudice, September 4th, solely on the quoted Constitution, right there, see? It's all in there. And here's the denial from the 12th District Court from Judge Gakey, which is why I ended up taking this to the 4th Judicial Circuit Court, because that's the next step up. Now, here's the denial, one page, simple. He just outright denied it for reasons he stated in court. In court, we will see, like we already covered in this other stuff, he called the Constitution frivolous and without merit. Here's the court transcripts. Public record. Prepared by Kamari Boomer, which is the court reporter and court recorder for Judge Gakey. Here is, this is going to get fun, Michigan Tenure Commission. I filed this because of the arrest on the child support charges. This is pretty small type, but that's the only way I could get all that in there. This is from June 28th. June 28, 2006, Judge John G. McBain giving a 90-day pay or stay, stating $5,000 is the total that I owed in child support. If I stayed the 90 days in jail, I didn't have to pay the $5,000. It was over. If I paid the $5,000, I didn't have to stay in jail. That's how pay or stay works. This is an original, true copy of an original from the court that I acquired on March 10th, 2011. This is the court order by Judge Nye. He put a stop to everything. He said they claimed I owed $24,000 something right there, and he put a stop to it. It's all right here. Poor copy, but I have better somewhere. This is Judge Rapley. She claims she was there for the June 12th hearing, but she actually files it on June 13th, the day she came back from her vacation. June 12th, she's signing this, claiming, and up here she writes Judge Nye was wrong. She doesn't have the right to overturn Judge Nye. She's not a higher court. This is the accounting that Judge Nye ordered a friend of the court to give me. It shows I have a zero balance. I owe nothing. These are register of actions for the lower courts, which are required in the 3 different cases. And this is the original ticket. This is going to come into play in a little while. You'll understand. Because it says, for location upon South Robert Street at or near Tyson. You're going to understand that in a minute, because Tyson and Roberts is not Summit Township. Therefore, the Summit Township charge that I was arrested for, where is it? Right here, does not apply. This is the ruling on defendant appellant's petition for review of reversal, lower court. This is from Judge John G. McBain. This is the one he based his entire decision for my interlocutory appeal on. This is the actual petition for review and petition for review of the decision by Judge Robert Gakey Jr. that goes with that decision. And this has to do with Second Amendment rights, not anything to do with whether or not law enforcement is constitutionally legal. This has to do with Second Amendment rights only. Whereas this where is it? Right here. My petition for interlocutory appeal had nothing to do with Second Amendment rights, but only whether or not law enforcement as we know it is constitutionally legal. The Jackson County Sheriff's Department is not a constitutionally legal form of law enforcement according to the Constitution or the Michigan Militia Act. Now, this was also filed with it. This is an order denying my motion for stay of proceedings. Again, he says for reasons stated in the trial, he doesn't put his reasons here in his order, which he's supposed to do. But if you go to the reasons in the transcripts right here, you'll see that it has to do with, he's calling my motion for dismissal with prejudice based on, and he admits it's based solely on the quoted text of the United States Constitution, and he says that it's frivolous and without merit. He's calling the United States Constitution frivolous and without merit. And because of that, he denied my motion for stay of proceedings, which I filed so I could take my appeal to the Court of Appeals, which I'm doing, which is what all this is. This is all filed in the Court of Appeals. Now, we come back over here. There's various proofs of service here. The neat thing about the Court of Appeals is it's almost all electronic filing. So it's all electronic proofs of service. The lower courts, I served like this by hand. Now, let's go around here. And I filed for a there it is. Defendant Appellant Bank Val Thulin, motion for immediate consideration and motion for stay of proceedings in the trial court 12th District Court Case 240248 SU, pending the final ruling of the Michigan Court of Appeals, case number 373263. That was served. I get back. That had all the various other documents with it needed. The order saying that the stay was denied, transcripts, all that's there. I get an order back saying I was missing something, defective, so I had 14 days to fix that. And within the very next day, I'm filing all new. Not all new, but I'm filing the necessary additional paperwork with it and the amended to show that I added these documents. Court trial schedule, 11:15 pretrial motions, final pretrial 11:26. List of exhibits and potential witnesses due. On the 29th. Proposed jury instructions. Settlement conference. That's on the 3rd. Trial date's on the 12th of December. That shows the urgency for the stay of proceedings, because they're doing this to try to prevent me from having my day in court in the Court of Appeals. That's what all this is about. Now I've explained it best I can. I'll make another video here in a minute explaining the ticket and its location, proving that is it in fact Blackman Township where I was, not Summit Township, therefore the Summit Township ticket and Summit Township charge does not apply, rather. Saturday, November 30th, 4:02 p.m. Pass this around, people. The whole damn country needs to know that, hey, you've been getting arrested by people who have no legal right to arrest you. No constitutionally legal right to arrest you.